Good luck. Love you too. Bye-bye. Bye-bye. Bye-bye.
Sorry, the delay in part was to commemorate the victims of the Tennessee tornadoes, which took longer than anticipated. We will resume, and we are now up to Mr. Dubbin. Is he not here yet? Then we'll move on to Ms. Kochen, and we will get back to Mr. Dubbin. Ms. Kochen, why don't you begin?
Chairman Frank and members of the committee, thank you for the opportunity to appear before you today.
I'm sorry.
I appreciate the committee's efforts to examine the issues underlying the Holocaust-era insurance claims, including the work of iCheck, in the context of considering this legislation. iCheck's mission was to identify and compensate previously unpaid Holocaust-era insurance policies. Under the leadership of former Secretary of State Lawrence Eagleburger, iCheck resolved more than 90,000 claims, ensuring that over $306 million was offered to Holocaust survivors and their heirs for previously unpaid insurance policies. Of this amount, more than half went to individuals that were unable to provide policy documentation or identify the company that may have issued the policy. The Commission also distributed more than, or nearly 200 million more for humanitarian social welfare purposes, largely to honor the memory of heirless claims. I hope to help you understand why and how the Commission approached its mission and how the organization was structured around that mission. As a former president of the NAIC and vice chair of iCheck, I participated in this process from its earliest days. I was joined in this effort by insurance regulators from all parts of the country who deserve even greater recognition for much of the work of iCheck. In particular is the work of New York and the late Neil Levin, who perished on 9/11, and Glenn Pomeroy, former president of the NAIC and North Dakota Insurance Commissioner. Credit also goes to the NAIC for their efforts to resolve the complex issue of unpaid Holocaust-era insurance claims. Through the participation of a diverse group, iCheck offered recourse to thousands of individuals who would not otherwise have had the opportunity to pursue their claims. We only came to appreciate the challenge we worked through with the undertaking. We were creating a process to address claims that were over 70 years old from more than 30 countries with more than 20 languages in currencies with no relevant value and with little documentation. To start, we researched the pre-war and wartime insurance market and then invested heavily in extensive global outreach. We utilized all means available and emphasized that anyone, regardless of the documentation they possessed, who thought that they were entitled to a Holocaust-era insurance policy should file a claim. We established an agreement on relaxed standards of proof and created valuation standards that could be calculated without usual policy documentation. We also developed an extensive research database and a matching system. Furthermore, we instituted a separate but related humanitarian claims payment process for unnamed, unmatched claims and for claims on Eastern European companies that had been liquidated, nationalized, or for which there really were no present-day successors. One of the Commission's first priorities was to gain a clearer understanding of the overall volume and estimated value of potential claims. Glenn Pomeroy, brother of your colleague, Earl Pomeroy from North Dakota, co-chaired a task force to explore these issues. The Pomeroy for Us task force, utilizing outside experts, guided the Commission in deliberation on how to assess appropriate settlement amounts across the markets in Europe, which ultimately resulted in overall settlements of approximately $550 million. iCheck's archival research was similarly critical to build on the information provided by claimants, constructing an iCheck research database that ultimately could be matched with the company's information. As a byproduct of this research, iCheck published the names of 519,000 potential Holocaust-era policyholders on its website. Finding a name on a list published by the Commission was neither necessary to file a claim nor proof that a previously unpaid claim existed. We recognize that our credibility depended on adequate oversight. For this reason, iCheck established 4 important processes. 1, a 2-stage independent third-party audits for the claims review processes of each participating company and partner entity. 2, an executive monitoring group that could conduct real-time evaluations of companies and the iCheck's claims operations. 3, an in-house verification process to cross-check every decision on every claim that named a company. And 4, an appeals process that allowed for any claimant to have a decision, named claimant to have a decision by a company reviewed. The successful settlement of iCheck claims, coupled with restitution efforts during the immediate post-war period and the ongoing work of existing entities to resolve the remaining unpaid insurance policies within their respective jurisdictions, addresses a preponderance of the pre-war insurance market. In addition, at iCheck's concluding meeting, every company that was a member of the Commission, as well as the 70 companies of the German Insurance Association through its partnership agreement with iCheck and the Shoah Foundation, reaffirmed their commitment to continue to review and process claims sent directly to them, which was confirmed by company letters. The work of the Commission was unprecedented, yet we were able, through amicable and inclusive dialogue, to voluntarily adopt a new approach towards the resolution of unpaid Holocaust-era insurance claims for the benefit of survivors and their families and those who did not survive. In the end, for me, it was about the people and their stories and about justice. The Commission could not resolve the wrongs done by the Holocaust, as that debt is incalculable. However, our efforts could bring some measure of justice to the lives of thousands of survivors, their families, and the families of those who perished. Thank you.
Thank you, Ms. Kochen, and we now go to Sam Dubbin.
My name is Sam Dubbin. I'm an attorney from Miami, Florida. I would like to explain to the committee how I got involved in this matter.
Ms. Dubbin, we have a limited amount of time. That may or may not be relevant to what we do on the bill.
I understand.
Use your judgment, but you don't have an unlimited amount of time.
I got involved because when I returned to practice law in Miami in the late 90s, I was approached by a number of Holocaust survivors, elected leaders of survivor groups who were very concerned about the way deals had been made and discussions were done over their rights. And many of them talked about insurance policies. And the survivors and I went to our legislators, and in the state of Florida, the legislation was passed that provided, based upon the testimony that the insurance commissioners had heard, because everybody recognized that today it would be difficult, or in the 90s it would be difficult for survivors to be able to know about a claim. So the legislation in Florida, like the legislation in several states, required the publication of names, and it allowed survivors to go to court with a 10-year window. And the 10-year window was extremely important because to have to litigate the statute of limitations under the circumstances would be an undue burden to impose upon people who obviously had been denied that information for years. So it was the heartfelt outpouring of desire for truth and for reconciliation with history and the ability to reconnect with what their families had lost from Holocaust survivors that got me involved. I have filed a number of lawsuits against certain insurance companies. I was one of the lead counsel in the Hungarian gold train case, in which we were able, with the help of members of Congress, including many people in this committee, to get a just resolution, and that was through the courts. And that's because the survivors had the ability to speak for themselves. And it's the denial of that ability to control their own rights through the courts of the United States that is the greatest abomination, really, of what's happened over the last 10 years. I want to remind the committee that those who are opposing the legislation talk about legal peace. What is legal peace? Mr. Eisenstadt has said in his book that during the negotiations over whether the German industry would pay slave and forced laborers for the torture that they inflicted on them, he said in effect that before they would make those payments, they insisted that the United States wrap insurance into that overall agreement at the 11th hour. Now, whether or not it's appropriate to negotiate by executive agreement payments about slave labor, which is a different kind of legal claim than a documented insurance claim. Remember, the policies, the documents are there in most cases. The companies have the documents in most cases. The reinsurers have the documents in most cases. So why there should be a legal or moral nexus between slave labor payments and the property claims like insurance claims is a very serious fundamental policy issue that this Congress should look at. It's also clear from Mr. Eisenstadt's book that the Germans demanded that the president agree to abolish people's rights to sue for insurance policies. And he's equally clear that the president does not have the authority to do that, and that the Germans then, in effect, gambled that the so-called legal peace that was agreed to would somehow prevail in the courts. And the Solicitor General, Mr. Waxman, evidently wrote a letter outlining that there was, under no circumstances, did the United States have the ability to abolish people's rights to sue for insurance policies. So today, the agreement provided that it was in the, quote, foreign policy, it would be that they would file a statement of interest that it was in the foreign policy interest of the United States for cases to be dismissed on any valid legal ground. Today, it's the interpretation of that in the courts that has caused the problems today. It's the court's interpretation of the executive agreements that now bars survivors from going to courts. Why? Because they've said it's not the agreements that matter. So when the State Department says here that we didn't agree to keep people out of court, that's disingenuous, because the courts have said there is a federal policy that operates separately from these executive agreements, from the language of the agreements, that they've relied upon to bar Holocaust survivors and heirs from access to the courts for insurance claims. So those who now oppose the legislation want to give Germany more than they were able to bargain for in connection with that executive agreement. Now, so the question is, if there is a federal policy about how Holocaust survivors' rights ought to be determined in the United States of America, the question is, did the president have the authority to negotiate away the rights of survivors to go to court as a practical matter, because it's not the agreement. The language of the agreement is more restrictive than what they've obtained today. The courts have interpreted that as embodying a policy. This is not about foreign policy. This is about international commerce, and it's about access to the courts of the United States. And those are areas that this Congress has jurisdiction over, pure and simple. And to the extent that there is an argument that there is a foreign policy element to that, there is no case, no principle where, in the absence of a grave international crisis and congressional authority, that based upon the president's word alone, people have had their rights to go to court denied. But that's the effect of the agreement and the subsequent court decisions. That's why the access to courts provision of this legislation is so important. So that leaves to the Congress the question of who sets policy about whether or not companies that do business in this country who sold insurance to people who live here today, and believe me, these policies, as I put in my statement, they were very explicit. When Victoria and Generali and the others sold insurance, it said, you can collect this policy anywhere in the world where you demand payment. And that meant something very special to Jews in Europe in the 30s, because they sure hoped they would be somewhere else or thought they might be when it came time to collect. So this is not about foreign transactions. This is about global companies at the time. They had assets in the United States at the time, and people today want to redeem those policies. These are contract rights, and to think that there's one class of people in this country today who do not have the right of access to courts to obtain compensation for contracts that were sold to their parents under admittedly unusual circumstances, but those circumstances, as you've heard from many people, shouldn't justify the denial of access. If anything, it should deny more favorable treatment, such as the publication of names, which is justified under the conditions, and the statutory extension of the statute of limitations. Is Congress willing to abide by the executive's judgment? there are two questions. Legally, there's no question Congress has the authority. Morally, do you accept the judgment that as a condition of allowing the German companies to make slave labor payments, that people's insurance rights should be obstructed the way they are? That's a decision for Congress to make. I would just close by saying that ICHEC, in spite of the accomplishments that it had, and there were some, its overarching purpose was to limit the financial exposure of the insurers and the moral exposure of the insurers. And by that I mean there are records that show what the companies did when the Nazis and the Axis came to collect people's policies. Those files exist. And the survivors have a right to know what someone who sold their parents' insurance did at the time the Nazis came knocking, what they did to identify their Jewish customers. That's as much a part as the compensation. And for that truth, and frankly, for fair compensation to be denied as a result of those transactions is really a travesty, and it's not the kind of thing that this Congress should associate itself with as far as the policy of the United States of America.
Thank you. Next, we'll hear from Roman Kent.
Thank you, Chairman Frank, and members of the committee for allowing me to appear here. I am a Holocaust survivor. I have received a bachelor's degree in Lodz Ghetto. I received a PhD degree in Auschwitz, Merzbachtal, Gross-Rosen, and others. Presently, I am chairman of the American Gathering of Jewish Holocaust Survivors, an officer of the Conference of Jewish Material Claims Against Germany, known as the Claims Conference. I participated in the negotiation leading to the establishment and was commissioner of the International Commission of Holocaust-Era Insurance Claim, known as ICHEC. I also participated in the negotiation involving the German Foundation and am presently also involved in the ongoing Claims Conference negotiation with the German government, which have resulted in provided hundreds of millions of dollars annually for Holocaust survivors. For 25 years, I fought for justice and memory of the Holocaust survivors. For this reason, I believe that I have a unique perspective from which to comment on the issues which are the subject of this hearing. At the outset, I want to highlight three key points. First, the ICHEC process has concluded. However, insurance companies which work with ICHEC continue to accept and process Holocaust-era insurance claims, applying ICHEC standard in their decision at no cost to claimants. In addition, a number of organizations, including the Holocaust Claim Processing Office of New York State, will assist survivors filing such claims at no charge. Second, the H.R. 1746, which generates huge expectation among survivors that will not be met. The cost, time, about everything time, and effort required to engage in litigation will be excessive, if not prohibitive. Even if European data protection hurdles could be overcome, the mandatory publication of the companies which work with ICHEC of all policyholders' names will, at that point, yield little new information regarding policyholders who were victims of Nazi persecution. Third, H.R. 1746, by effectively reopening previous agreements, will certainly, and I want to emphasize the word certainly, damage ongoing negotiations with Germany, among others, and will put at risk hundreds of millions of dollars in crucial funding which is required now for the neediest Holocaust survivors. Since the beginning of World War II, and for the next 60 years, few survivors recovered the proceeds of their unpaid Holocaust-era insurance policies. They faced an enormous obstacle, including the resistance of insurance companies to pay or even give a fair hearing, the virtual impossibility of obtaining relevant documents, and the statute of limitation. Moreover, many companies were no longer in business after the war. A communist regime barred any sort of recovery for survivors in many countries. Clearly, Clearly, there was a vacuum in post-war insurance resolution effort. No effective forum existed. This is precisely why the ICHEC agreements was reached. ICHEC developed a process and methodology to identify and compensate previously unpaid individual Holocaust-era insurance claims at no cost to claimants. Working with the insurance companies that had agreed to participate, ICHEC made great strides to fill this void and attain a measure of justice for claimants, which up to that point had not existed. However, only 5 European companies which signed the agreement to work with ICHEC and the German companies which were part of the German Foundation agreement provided funding for ICHEC. ICHEC received no other funds from any companies which were part of the European insurance market. Nonetheless, ICHEC developed a special process to make payment even for policies issued by such companies. Moreover, many complications arose with the companies that did work with ICHEC. For example, the different data protection of privacy law of Germany, Italy, France, and Switzerland had to be addressed individually. ICHEC also developed a liberal approach towards evidence to make it possible and easier for claimants to recover. Only a small percentage of claims named a specific company. Much fewer still included any documentation linking the policy to the specific company named in the claim. Yet, ICHEC did something no court would do and developed a way to pay claimants who did not produce an insurance policy or name a specific company. Thus, to address the ineffectiveness of lawsuit, ICHEC became the first, and indeed the only organization to offer Holocaust victims and their heirs a way to pursue Holocaust-era insurance claim at no cost without regard to any statute of limitation, even if the policy in issue could not be produced. An assertion had been made on a number of occasions that less than the 5% of the total value of Jewish Holocaust-era insurance policies was paid through the ICHEC process. This is a figure without any solid basis. As I have noticed, ICHEC paid claimants for insurance policies issued by companies in Eastern Europe which no longer exist. Beyond that, the ultimate percentage of the Holocaust-era insurance market paid through ICHEC depends on the valuation of Jewish purchases policies in question, and that, in turn, will vary depending on which volumes out of the broad range of possibilities are used in the relevant calculation. The factor involved in the complex calculation required included the following: the total pre-war face value of all insurance policies in the local currency at the time, the Jewish share of such policies, the propensity of Jewish individuals to purchase insurance in greater numbers and at a higher value in the rest of the population. 4, an adjustment for policies which were paid. 5, the method used to convert the value of unpaid Holocaust-era policies in today's value. That is, there is no single correct measure for any of these factors. The final conclusion one can reach will radically, and I say radically, differ depending on which values out of the extensive range of possibilities were selected for the relevant component factors. To summarize, was ICHEC perfect? Hell no. Excuse me by saying hell no. Let me correct it by saying clearly not.
I would instruct the recorder, hell can stand.
Thank you. Thank you, Mr. Chairman. Nothing can remedy the wrongs perpetrated during the Holocaust. The life of one child and 1.5 million of children, and I was a child, cannot be measured in dollars and cents. The most that can be achieved is an imperfect justice. Imperfect justice on this planet. We do not have a perfect justice on this planet, yet I hope maybe sometimes we will. Yet, as imperfect as ICHEC was, what it accomplished was without precedent. 1, iCheck provided a forum for
We're going
Holocaust.
to have to speed this up, Mr.
Yes.
Kent.
One more minute, please. iCheck provided a forum for Holocaust-era insurance claims where before, practically speaking, there was nowhere to go. Second, iCheck did not charge survivors, nor was it bound by any statute of limitation. Third, iCheck paid on policies issued by insurance companies which no longer exists. Fourth, insurance companies which work with iCheck continue to accept and process claims, while the Holocaust Claim Processing Office will assist applicants with filing claims. Fifth, based on iCheck research, an archive consisted of over 520 most likely Jewish insurance policyholders is now available to survivors, historians, and other researchers. And finally, about $600 million of Holocaust-era insurance policy was paid to policyholders and heirs and to program benefiting survivors, and it was paid based on iCheck standards.
So that'll have to do, Mr. Kent.
Yeah, I just...
You said another minute and we're over that.
Yeah, no, I do appreciate. I just have to finish it.
10 seconds.
I cannot do it. I am...
Then we'll get back to you in the questioning. We're going way over on all these, and I did try to advise you this. The next witness will be...
Can I just finish my conclusion?
No, we'll get to you in the questioning. Mr. Zabulov.
Sure.
Thank you for allowing me to present the facts relating to the restitution
your
of
microphone's not on.
Holocaust-era assets. Is it on? Good. Oh, maybe it's not talking. Okay. Clearly, the murder of two-thirds of continental European Jewry and the confiscation of nearly all Jewish assets by the Nazis and their collaborators was such an event. Despite the extraordinary circumstances, only about 20% of the stolen property and other assets have been returned. Two bold actions could be taken to rectify this sizable and unconscionable shortfall. They are the passage of H.R. 1746 and ensuring that the remaining unpaid stolen assets are used to assist needy Holocaust survivors. In the first case, 1746 would help restore the Holocaust victims or their heirs the value of policies never paid by insurance companies or countries. That amount is conservatively is about $17 billion in today's prices. The bill's important first step is to ensure the names of policyholder names are published. iCheck started this process, and some 500,000 names were placed on its website. Germany produced about 80% of these policyholder names. In the iCheck context, however, the German list was of little use since it was made public only a few months before iCheck's filing deadline. For all other countries, the number of Jewish policyholders published is minimal. The most notable shortcomings are in Hungary, Poland, and Romania, all of which have large pre-Holocaust Jewish populations. Even in most West European countries, the number of published names is extraordinarily small. To deal with the shortcoming, non-German archives need to be further examined, and most importantly, companies doing business outside Germany should publish the names of the policy-era holders. The proposed legislation also provides victims and their heirs a means to receive a fair value for policies taken out in the Holocaust period. This recognizes that there's still a long way to go for life insurance companies to meet their Holocaust-era obligations. Even at most, about 11% of the fair value of outstanding policies was paid during the post-war and iCheck years. H.R. 1746 provides the last opportunity to increase that percentage. Again, there are differences between Germany and other countries. Germany is the only entity that has pledged to continue to accept claims and pay them under iCheck guidelines. There are, however, very serious negative aspects of the seemingly benevolent action. The German Association will not accept claims that do not name companies. This is an enormous drawback. Nearly all the 400,000 German names of policyholders listed on the website do not indicate a company name. and iCheck experience clearly demonstrates that 2/3 of the claimants did not know the company name. Thus, this German action is of little benefit to the claimant. Also on the downside is the method Germany insisted upon in using and determining a policy's current value. It produces an amount that is only about 15% of similar valued policy paid under iCheck guidelines for all other West European countries. In special arrangements with other European countries, iCheck achieved little in settling claims. A number of these shortcomings are illustrated in my written presentation. The chief reason for iCheck's problems were inept governance and poor management. Governance became akin to secret diplomacy, in which those who ran iCheck relied heavily on dealing only with those who favored their views while making promises to others that were not fulfilled or long delayed. Judge Michael Mulcahy succinctly summed up the problem when he described iCheck, and I quote, "the company store." But no matter what steps are taken to find claimants, many policies will remain unpaid. Those working on iCheck and other restitution efforts recognize this outcome from the start. This is because whole families were wiped out by the horrific events of the Holocaust, leaving only distant relatives with knowledge of their policies, especially when dealing with events of over a half a century ago. It is also understood that many records no longer exist. For example, the extensive search of life insurance records in Germany yielded about 8 million policies, or only about a quarter of the policies outstanding in the late 1930s. Recognizing this fact, iCheck attempted at one time to calculate the overall value of policies, called the top-down approach. The companies would then pay the difference between the overall estimate and the amount actually paid to claimants to a fund that would support needy survivors and other causes. This approach, however, was quickly forgotten as iCheck proceeded, and relatively small amounts were provided for such a humanitarian fund, mostly under the accord with Germany. Insurance companies failed completely to deal with this issue. This brings me to my last point. Besides pressing individual claims, I would suggest an international remembrance fund to support needy Holocaust survivors who are in their autumn years. Currently, there are approximately 600,000 Holocaust survivors worldwide, and actuarial data indicate that the number will decline sharply during the next 10 years. A review of available studies indicates there are numerous survivors who lack adequate income to meet their daily expenses and health requirements. For example, one study of the United States indicates the income of more than half of the survivors fall within the poverty or near poverty bracket. Clearly, what is urgently required is an in-depth study to determine more precisely the likely financial requirements of needy survivors. Simultaneously, we must reach a global accord to establish an international remembrance fund. This will require innovative financial structure. But again, extraordinary measures are essential in dealing with an extraordinary event such as the Holocaust. Thank you.
Thank you. Before we get to the questions, we've received several letters. I will, without objection, read into the record. The World Jewish Congress expresses its opposition to H.R. 1746. It says that negotiations for the future will be irreparably harmed. The B'nai B'rith International expresses reservations and asks that we take these considerations into account. We worry that the legislature would unfairly raise the hopes of survivors without being able to satisfy the negotiations, and expresses concern about future negotiations. The American Jewish Committee says that the bill could affect adversely similar negotiations in the future, and says it believes current measures are adequate. And the Anti-Defamation League says that H.R. 1746 is unnecessary and does not serve the needs of Holocaust survivors nor the interest of the credibility of agreements on these matters. They will be part of the record. The record remains open if others wish to submit, and copies of these will be available if anyone wishes to comment on it. One just technical question as to timing, Mr. President. When did this all get finally done? The agreement? You referred to a period of my being the ranking member. I became the ranking member in 2003.
In 1998, February 12th.
No, I said Mr. Eisenstadt.
I'm sorry.
I testified September 1999.
Yeah, I was not the ranking member. I just wanted to. I knew that Mr. Leach and he was the chairman. You said I was the ranking member. I didn't become the ranking member till January of 2003. Mr. LaFalce was then the ranking member.
You're correct.
Let me raise one question for those who are opposed to the bill. Mr. Zabutoff referred to the fact, and I'm told by some of the staff, that there's a different response from countries. That Germany, in fact, has been more responsive than some of the others. If we don't do anything legislatively, what can be done about those countries that have not been responsive? I'm told the Netherlands, Austria, maybe Switzerland. Is there something that could be done about countries which have not been responsive, even if you think the terms were acceptable? Any of the three?
Well, I would only mention that with regard to iCheck, we did archival research in quite a few countries, and we entered into agreement.
What do you disagree with the notion that there's been a differential level of response?
I do believe that in many of those countries there are mechanisms in place.
No, Ms. Kogan, I'm sorry, but I'm tired. I've been here all day. That's not what I asked you. I'm sure there are mechanisms. Do you agree or disagree that there's been a differential level of response?
I believe that some of those countries have not completed their work yet in their process.
Okay. Do you think, is that just a timing thing? Are they just, they were busy that day and couldn't get to it? I mean, why is some slower than others?
The two countries that I know that have not completed would be Switzerland and Austria, and they are still working on their processing. I would not be an expert.
All right, well then, I don't mean to be rude, but if you're not, don't answer the question. I was unfair to the Netherlands, apparently. I guess the problems are in Austria and Switzerland. Mr. Kent, did you want to respond to that about Austria and Switzerland?
I would like to first, with your permission, Chairman Leach, to finish what you said. I will.
If you could do it in 30 seconds, Mr. Kent. You had over 10 minutes for a 5-minute period.
Finally, I am extremely concerned that the legislation, which certainly, this was your question too, certainly damage critical ongoing negotiation, especially with Germany, involving hundreds of millions of dollars in Holocaust-related compensation, which is needed now, not tomorrow nor next year, but now. I also fear that the support the United States government provides Holocaust survivors will be undermined as other governments lose faith in the ability of the U.S. to keep its promises. Reimbursement.
No, I'm sorry, Ms. Kent, that's enough. You're abusing the privilege of the committee. You had over 10 minutes. I've listened a lot. I now want to get to the questions. What about Austria and Switzerland? Are they a problem, or are they, and if they are, do they get left undone?
I cannot tell you, but Eastern European countries, yes. We have spent over $31 million to pay claims for Eastern European countries. You as the Congress can do something. You can help us to collect from them the money. That you as Congress could do.
Okay, then, and that's an important point, but I still want to get back to, does anyone have any response to the question that even within the terms of this agreement, Austria and Switzerland have not been responsive, I'm told. If people think that's not true, they should tell us. And can we do anything about it? Mr. Zabutoff.
Yeah, I just wanted, you raised the question about Austria and Switzerland. And in the case of Austria, they allocated $25 million for life insurance. And that was in relationship to iCheck. Because there was only $25 million, they've just sent out notices, or fairly recently, that they're only going to pay 15% of that because they don't have the money.
All right, well, then let me raise that question to people who are opposed to the bill. Where does that leave people who have a claim against Austria, even under this procedure?
Yeah, people have...
No, I mean...
Okay, I'm sorry.
I was wondering if any, because a strong argument has been made that Germany has acted in good faith and made a deal, but there are other countries, and the question is, what do we do about these other countries? That's as much answer I guess I'm going to get. The other point would be, yes.
Well, I would say that iCheck did pay a number of the claims of the Austrian about $10 million because we wanted to make sure those claimants were not left behind. But I might suggest that might be a level of inquiry for this committee, is to ask each of the countries to set out what they have done. I know in 19...
Well, no, that's not my question. We have all the, but the question is,
Chairman, can I take...
can we do something to make them do it? I mean, you're saying we made good because Austria wouldn't? Is that iCheck did? Is that the, not we, but iCheck? Yes, Mr. Eisenstadt.
The issues that I've raised, and perhaps Mr. Kent as well, refer...
please answer my question, or else we'll
I'm
pass
answering
on.
the question.
No, I'm talking about Austria and Switzerland.
Refer only to those companies that are have participated in iCheck that included certain Austrian and or adopted iCheck policies. It did include certain Swiss and Austrian companies. If there are Eastern European companies that did not participate in iCheck, the legal peace issue... I
understand that. Now let me get back. Are you saying that, but with regard to Austria and Switzerland, maybe, again, people have
There are a
exaggerated.
number of Swiss companies that Winterthur and Zurich and so forth, which were part...
Is there a differential pattern, though? Are there companies in Austria and Switzerland, and as a whole, are they doing less than they should be under the agreement? The fact that some companies are doing well doesn't answer the question about others. It's not a trick question. I'm trying to get information.
Well, I guess the question is the agreement when you refer to the agreement. With regard to iCheck, the companies all applied the standards equally. So to the extent that Zurich and Winterthur were in iCheck, we're very satisfied with the work that they did.
What about all of the... But you just said that Austria was not living up to its agreement.
To the extent that there are separate entities that were created, the bank, Swiss bank settlement, which is what Swiss Re is participating in, and the Austrian, they haven't completed their settlement work, so we can't.
Well, are they? I mean, what's the timetable? When are they going to do it? We've been doing this for a long time.
That's a good question. That's a very good question.
Well, that sounds to me like some fraud might be.
Chairman, if I can say something to you, several years ago, I testified here in the Congress. And I've told them, if you want to do something, that means if the Congress wants to do something, stop giving license to the insurance companies that do business and they do nothing to help Holocaust survivors. Unfortunately, I must tell you, it's easy to sit here and hear the criticism, but Congress didn't do anything about it. I gave them a strict proposal.
Well, I don't remember that. I will say this, though, that I'm not sure what... Excuse me, Mr. Kent, I'm going to respond. Congress doesn't license insurance companies. The states license insurance companies. I will look into that specifically, but I don't know what licensing that the Congress would have been involved in. In fact, my European friends complain to us all the time that when they want to sell insurance in America, they got to go to 50 some odd different jurisdictions. So I don't believe that the Congress has been allowing that, but I will look further into what you're doing. But that's still, I mean, I am somewhat disappointed. I thought I was asking a fairly straightforward question about a differential level of compliance and whether or not that's something that needs to be addressed. We'll now move on to Ms. Voss-Lehtinen.
Thank you, Mr. Chairman, again for letting me participate. One multi-level question for Mr. Dubbin, if you could answer in the allotted time. Some opponents of H.R. 1746 have stated that it is premised on inaccurate estimates of the unpaid value of Holocaust victims' policies. Secondly, that it violates deals to provide legal peace for German and other insurance companies that participated in iCheck. And thirdly, that H.R. 1746 isn't likely to produce enough successful claims by survivors to justify the political cost of the ill will that it would engender among foreign governments whose insurance companies profited from the Holocaust. If you could refute those or not refute them.
On the value, Mr. Zablodoff, who participated in the iCheck group analysis, which was consensus, there was a consensus that at the time, in 38, the value of, there was a consensus about what the value of Jewish policies was. He calculated the amount that had been paid after the war in various programs, and then taking the remainder, which was slightly under $600 million, he multiplied that by the yield of the 30-year U.S. bond from 1938 till the present. And with that, he got, in 2004, $15 billion. Now it's $17 billion. A 30-year bond yield is extremely conservative because most insurance companies invested in stocks, real estate, and other much more high-yielding investments. So there is no dispute about the underlying numbers, and ICHEC never undertook to go to the next step, which is to take the value in 38 and bring it up to current levels. So the $17 billion figure is very solid. But if you, as Mr. Wexler said, if you accept the $3 billion level, what ICHEC paid out would still only be 15%. But under Mr. Zabladov's conservative numbers, which are not challenged in any, I have not seen a theoretical objection or factual objection to what he said. The second question was legal peace. The U.S. government does not have the power to waive a citizen's right to go to court. Germany demanded that. They were told, you can't have that. What the United States agreed to do was very limited, and it said that we will file statements of interest in court, which would say that it's in the foreign policy interest of the United States government for the case to be dismissed on some, if there is a valid legal ground for doing that. And the Germans accepted that, understanding that they were not getting everything they asked for. So today, to say that we agreed that survivors would not have the right to go to court is disingenuous. In fact, it's giving the Germans more today than they bargained for then. And the reason it's necessary is because the courts have interpreted that commitment more broadly than the language the Germans were actually able to negotiate for. Because the courts have said, it doesn't matter what the language in the agreement says, which is limited. We think there is, in addition to the language, in addition to the contractual language, there is a federal policy of the executive branch that Holocaust victims' insurance policies should be resolved in a non-adversarial setting. So the question for you is, now, because the legal landscape is clear, do you agree with that policy? Does Congress agree that someone today who has a piece of paper from Generali or Allianz, which was denied through ICHEC, do you agree that person should not have the right to go to court and have a judge force the company to disgorge all of the relevant information? Because I can tell you from ICHEC experiences, and I can give you many examples, those companies were able to deny claims without providing the information to the claimant. So you have a star chamber system where the claims were denied. The rules might have said one thing, but the practical application was thousands of people were denied claims without getting any documentation, including people that Mr.
If I could
Virtual,
interrupt you because our time is limited.
So the last question is the cost-benefit analysis.
Right.
I don't believe that human rights are subject to a cost-benefit analysis. The right to go to court to pursue your documented insurance claim or to pursue a company you believe sold you a policy if you can convince a lawyer to bring that case. In the United States of America is a fundamental human right. It's enshrined in the Constitution and the constitutions of every state. And to say that we're going to force some people not to be able to avail themselves of that right because other groups, and by the way, I don't care what groups sat in a room. Izzy Arbeiter, David Mermelstein, Jack Rubin, Alex Moskovic, and hundreds of survivors who I personally have come in contact with did not authorize any organization, did not authorize the State Department, did not authorize the Secretary of State, did not authorize the President to negotiate for their insurance rights.
Thank you, Mr. Chairman. And although I'm not a member of this committee, and you've been very kind to me, I will.
May I respond to this?
I will ask if I.
Congresswoman, may I respond?
Excuse me, Mr. Chairman. I will ask a member of the committee if they could introduce, and for the record, some of the letters that I have gotten from constituents who.
Yes,
are
I'll be glad
aware
to.
of the legislation.
Our colleague from Florida, Mr. Wexler, would also be putting material into the record. Anyone who wants to can get it. Mr. Eisenstadt?
Congresswoman, the good faith of the United States government is at stake here. We negotiated in the open with congressional understanding and support $8 billion worth of agreements. Companies paid billions of dollars for slave labor payments, for insurance, for a variety of other claims, in return for which we gave a legal peace agreement which the courts have upheld. And we did say it was in the foreign policy interest of the United States to dismiss claims if there was a valid legal ground. That's what the Germans accepted. That's what we gave them. The courts, in their own wisdom, including the United States Supreme Court, have upheld that. If we now try to vitiate that, the whole negotiating posture that we took would be undercut. The whole reliance that companies had paid billions of dollars, and governments, the Austrian government contributed, the German government contributed, not just their private sectors, would be vitiated. Second, this is not an all or nothing thing. I have suggested in my testimony that we should hold the companies who have pledged to continue to honor claims on an I-check basis with loose rules of evidence, which would not have existed in court. Mr. Dubbin's remedy would have left, if we hadn't gotten this $8 billion, he would have been trying to get a class action approved by a court under rules of evidence when they didn't even have the names of insurance companies oftentimes, let alone the policies themselves. That's why we set this administrative process up. What I suggested is let's hold the companies to their commitment to continue to handle claims in an I-check-like process. Force them to report to the Congress and to the State Department. Hold oversight hearings. Get the German Insurance Association to submit regular reports on the number of claims that were filed and so forth. So there is something that can be done here.
Thank you. I fully agree with Secretary Eisenstadt, but Chairman Frank, I would ask you to do something. No, I really would beg you to do something. Close your eyes, and the members of the Congress. Don't see me as I look right now. You see me right now as you talk in your bill. The needy survivors that need help. This is what we're talking about, the needy survivors that need help. And let us consider for a second, I am here one of the survivors only, except for Ise Arbeiter, who happens to be a good friend of mine. I like to see what is the motivation of the bill.
I'm sorry, Mr. Kent, that's not something we're going to go into at this point. I will tell you this. I believe the motivation to be that members of the committee feel that they can do things to help people. But the motivation of individual members is not the subject of the hearing. I am sorry, and I understand there's anguish, Mr. Kent. There is a limited amount of time. You have had a great deal of time to speak, but getting into an examination of the motives of the members just is not something we're going to do.
But, no.
Thank you, Mr. Chairman. Mr. Secretary and all, I want to thank you for your testimony. Because time is of the essence, I'd like to start with you, Mr. Secretary. You indicated that there was and is, I think, congressional understanding associated with this agreement. Could you please explain what congressional understanding means?
Yes, sir. I testified time and again before this committee, before Senate committees, before the House Foreign Relations Committee, before the Senate Foreign Relations Committee, before the Senate Banking Committee, before the House Financial Services Committee about these agreements, about legal peace, about what we were trying to do, about what we were trying to accomplish in very extensive hearings. Now, no one sought legislation because legislation wasn't appropriate. We did this under the foreign policy powers of the President of the United States, but we did it in full consultation. Second, it was not done in a dark room with a few parties. We had plaintiffs' attorneys, not Mr. Dubbin, he didn't want to participate. We had dozens of plaintiffs' attorneys, the best class action lawyers, Mel Weiss and others around the country, Bob Swift from Philadelphia, people in Washington, major class action lawyers who decided to drop their cases because they realized that those cases did not have much of a chance, and indeed the two major slave labor cases were dismissed by judges on the grounds of statute of limitations problems. We had major Jewish organizations who participated in negotiations. We had representatives from the State of Israel. And we brought the Congress into it by our testimony. So this was done in very broad daylight Obviously, the actual details were done in private negotiations, but this was not an unknown quantity that was just dropped on the Congress or dropped on survivor groups. They were part and parcel. The American Gathering, the World Jewish Congress, the Jewish Claims Conference were all involved in every stage of the negotiation.
Did Congress ever have an opportunity to, in some way, sign off on the agreement?
They had every opportunity, if they wanted to object, because I testified. I laid out what the agreements were. If they had any criticism, they weren't heard. What I heard was praise and bipartisan support for doing something promptly that courts wouldn't have permitted. If you look at these cases, what court in the world would have granted jurisdiction to companies that didn't even do business here? What court would have allowed payment of policies when the claimants didn't know the names of the companies, when there weren't evidence? I mean, of course, the tragedy is that there wasn't evidence because they were burned along with the people. So we had to deal with that imperfection.
Let me intercede. I think you've raised a good question. Mr. Durbin, would you, excuse me, I'm sorry, would you please respond to the question that was just posed about the courts?
Well, let me address a couple of the points, if I might. But the lawyers who sued the German companies, who were part of those negotiations, had filed suits on behalf of individuals. So those cases had not been certified as a class action. That's important. So they voluntarily dismissed their cases, their individual cases. But they said at the time they dismissed them that the court should satisfy itself at the end whether or not the German Foundation is capable of providing compensation to insurance claimants. So now you're looking at, even just those lawyers understood that this was still contingent on a successful outcome. Now, several members of Congress, 47 to be exact, wrote letters to the Attorney General in the year 2000 rejecting the notion that insurance claims estimated to be worth billions could be satisfied by the arbitrary 300 million Deutschmark set aside in the German Foundation Agreement, and saying we were shocked to learn that the recent slave labor settlement between the U.S. governments and Germany included insurance. That's what members of Congress said. And what the Justice Department responded by saying was, hey, we didn't waive anybody's rights. We were just going to file a limited statement of interest. That was what the Assistant Attorney General for legislation said. And he also said that if this doesn't work out, we reserve the right to revisit our views on the constitutional issues. So Congress objected in the only way they could at the time. It's true they could have passed legislation. But the fact of the matter is there were objections from Congress, and the Justice Department attempted to salve those objections by saying if this doesn't work out...
Intercede. I have one more question I have to ask Mr. Zobodov. Is that correct? Am I pronouncing your name correctly, sir? Please forgive me. You mentioned that claims that do not have, cannot name an insurance company. You spoke about that and how they would be rejected. Would you, and this is my final question, so could you please explain that again for me?
Sure. Yeah. In the case of Germany, Germany did publish a lot of names. 400,000 names. 360,000 names that were from the German Accord and was published by the German authorities. Another 40,000 came from iCheck archive. So you have about 400,000 policies altogether. Now, the real problem is that when you look at that list, it doesn't list the company. So if you have to name a company, the GDV, which is the German overall company, overall of regulators of companies, they basically said you have to name a company. But the list doesn't show the company. So how could you do that? And we know from iCheck experience that 2/3 of the people who send in claims did not, years and years before, did not know the name of the company. So how could you expect a claimant to know the name of the company?
My time is up, sir.
I have 15 seconds because Congress did in 2003 pass the Foreign Affairs Authorization Act of 2003, which required the State Department to get reports from iCheck about its performance. And for 4 years, iCheck refused to provide the State Department anything, even though statutorily mandated by Congress.
Mr. Green, you want to finish up with it?
Thank you, Mr. Chairman. I'll yield back.
We've been joined by our colleague again from California, Mr. Sherman.
Thank you, Mr. Chairman. A lot of discussion has been here about how we've done the best we could under current law. We're in the business of changing laws here in Congress. And I've approached this from a consumer protection standpoint. Neither the State Department nor the Jewish Claims Conference has a responsibility to make sure that people in the 27th District are not sold life insurance policies by grave robbers, pirates, or their affiliates. That is the responsibility of myself and my colleagues on this committee. And there are so many reasons why somebody might buy an insurance policy, their family would be unaware of it, and they might lose all contact with the company, and then, according to the company's own records, they have an insured who's 100 years old, 110, 120. There's been no claim. Mr. Eisenstadt, would you ever buy a life insurance policy from a company that didn't have it as its policy, that if there'd been some great social disruption, so families and records were destroyed, that they wouldn't put up on a website your name on your 100th birthday so that your next of kin could make a claim, but would instead want to, in effect, be grave robbers, to hope that 100 years would pass after your birth, 200 years, 300 years, and there just wouldn't be any claim?
The answer is no, and that's not what happened here, Congressman Sherman. 519,000 names were published on a website.
I'm not just talking about the victims of the Holocaust here. We have the victims of the Armenian genocide, but we have millions of people who are not targeted for genocide, whose families were destroyed in World War II, and you've got all the consumers in the United States. Why would any company not post on a web page the name of an insured under the following circumstances? The insured is over 90 years old, and the company hasn't any contact with them or their family for 30 years. Why wouldn't we require that of domestic companies, international companies, World War II companies, World War I companies, Ottoman Empire companies, companies that sold policies in Poland or Albania? Why wouldn't we require that of anybody who would come into my district and say, we have clean hands, we should be allowed to do business in the United States?
Well, that's certainly not what this legislation does. This legislation is applying to European insurers who have privacy laws that preclude them in their own countries from doing so, but the way in which that was avoided, to the extent possible, was that of their 8 million...
So wait, excuse me, Mr. Eisenstadt. I've got such limited time. So these companies get privacy laws passed in their home countries. You know, a lot of insurance companies are going to get...
Mr. Chairman, of their 8 or 10 million policyholders, those were all given to the iCheck process. They were used by Yad Vashem to vet out...
Mr. Eisenstadt, you're giving me the details of what was done, and I'm asking a much broader consumer policy issue. Because what you're describing is a policy that did nothing for Albanian families or Armenian families.
I'm not here to... I can't answer broad consumer protection. I'm here to defend an agreement which got $8 billion for survivors in return for legal peace.
I'm not here to...
I'm not an expert on consumer protection on insurance.
I'm not here to attack that agreement. I'm here to say that we ought to have an overall policy, starting with the Holocaust, of requiring placing on the web the names of insureds whose families obviously are owed money. They're obvious, you know, these are folks that are well over 90 years old. They've lost attention, and your response is, well, these companies might have to comply with privacy laws in their home country. I can't imagine a home country privacy law that wasn't there at the behest of the insurance company if its sole effect is to simply deny the payment to families where the insured is 100 years old, 110, 150 years old.
No, sir, my response was that 519,000 names were supplied after they were vetted of 8 million by Yad Vashem.
I thank you for your work. I would hope that this would be the first step in requiring us to use the new technology, the web, to publish the names of those insureds. I can't see how a life insurance executive could go to sleep at night knowing that they have in their files unclaimed policies of insured people who obviously died in the World War II era, and they still haven't made payment. I yield back.
Mr. Arbiter, want to respond, I think, in part to that question.
Mr. Chairman, I keep hearing here about legal peace for Germany, for the insurance companies. What about justice for the Holocaust survivors? What about the insurance policies that were written in behalf of our parents, our families that were murdered?
Mr. Arbiter, I appreciate that. That's a substantial repetition. I mean, we understand that. That's the general one. I want to ask, if the gentleman's concluded, two questions, one to each side. The privacy issue is concerning, and I would ask the proponents of the bill, what if I am somebody in the Netherlands who doesn't want my family's insurance policy out there for everybody to see? What's our response to that? I mean, there's a legitimate privacy concern. So as I understand it, we're talking about putting everybody's insurance policy on there. What if I had a relative I didn't like and I didn't want her to know that I had an insurance policy? What's our answer to that? Mr. Dubbin, Mr. Arbiter?
Well, this bill calls for policies that were issued prior to 1945 to be published. Those are, to think that that's going to infringe on anyone's current privacy rights, I think, is a stretch. Our state treasurer puts the names of dormant bank accounts and things all the time. I mean, I think it's fatuous to make that argument from the other side, because insurance companies control. We know that those privacy laws are there to protect much darker secrets. And Mr. Eisenstadt said they published 519,000 names. They managed to publish those names, okay, even though they were privacy.
All right, let me ask, is this only uncollected claims?
The legislation calls for all policies to be published, all the policies that were sold. The reason for that,
including whether they were collected on or not?
Right.
Because they might have been collected wrongly. Well, I understand your argument, but I would disagree with your dismissal of those as fatuous.
I retract that statement,
Thank you.
Mr. Chairman.
I can understand people having...
I think it's not... Ultimately,
you retracted. Why don't you leave it?
Balance.
My advice, free, leave it with the retraction. Don't characterize any further. But I have to tell you, I think that is a legitimate issue that we have to take into account. Mr. Kent, did you want to comment on that?
Yeah, Mr. Chairman.
On the question of the privacy.
I'd like to see the laws.
Just the privacy. I'll give you an example in the United States. I mentioned we have about $30 million of policies that we paid out and we want to collect the money. Now, the privacy law in the United States is right now, we cannot get the name of the people because they are right now subject to United States privacy law. So I cannot even collect the money here that we paid out, iCheck paid out, because of the privacy law. So
you can't collect from Austria, is that what you're saying?
From Poland, from Czechoslovakia.
Right, I understand. Yeah, from other countries.
That's the
all right, thank you.
in the United States.
Let me now ask on the other side, and I'm not as... My memory is not as refreshed about law school, and I haven't ever practiced law. But on class action suits, in general, in the United States, I am a member of a class that has suffered harm. A class action suit has been brought in which I have had no involvement. I have not been given the option of opting out. Am I concluded, Mr. Eisenstadt or Ms. Cochran, am I concluded by the results, or do I retain a separate right to sue? Ms. Cochran?
In the iCheck process...
No. I don't know why. I know my
action.
diction isn't great, but let me try again. In general, in the United States, if there is a class action suit brought, and I'm a member of the class that suffered the harm, but I was not involved in the suit, I was not given a chance to opt out, am I concluded under American law by the results of that class action suit? Mr. Dubbin, you may be the only practicing lawyer among us, so.
If the settlement is subjected to a Rule 23 fairness process where there's notice to the class of the terms of the settlement and the judge approves it as being fair, and then it's either appealed and the Court of Appeals upholds it, or if it's not appealed, then if you're a member of that class, you are precluded. Now, that's what happened in the Swiss bank case, but that did not happen in
all right, and the rule, under the Rule 23, what is the Rule 23 procedure?
That's the rule that authorizes class actions.
One second, but what's the procedure they would have to go through?
All
They notify me, and I can opt out? Is that what...
the point, the rule says that all class members who can be identified through reasonable effort need to be given
Right, but
individual notice.
it's one thing to get notice. What can I do with the notice?
You can
I opt out?
Opt out.
Okay.
It has to inform you of your right to opt out.
So you are concluded only if it can be reasonably assumed that you were notified and declined to opt out. Is that
And there was a full Rule 23 fairness process presided over by a judge.
And only the
if we all
only
knew
the
what Rule
Swiss bank
23
case
said,
did that.
excuse me,
I'm sorry?
Only the Swiss bank case.
if we all knew what Rule 23 was, we wouldn't be going through this step by step. Stop with the specific references. I want to get this done clearly. In general, if you were notified and had a chance to opt out, and you didn't opt out, you're concluded. But if you did not get that notice, or if you opted out, you're not concluded.
The law says that...
Well, they didn't make a good effort to give you the
right.
notice.
If a court says the notice was reasonable under the circumstances,
Right.
you could well
Thank
be
you.
precluded even though you didn't get notice.
Right, but they had to have made it right. Mr. Eisenstadt.
Just to clarify, as Mr. Dubbin correctly said here, the Swiss bank case was such a class action settlement. It did preclude it, but the others did not. They're subject to this statement of interest, but they did not preclude you
So the
from
question
going...
then is, why should some Holocaust survivor who did not agree with the settlement be precluded from pursuing his or her rights independently?
They're not precluded. They can still sue. They would be subject to the statement of interest.
Statement of interest by whom?
By the United States government, pursuant to our agreement, in
Okay,
return for
so
the
they
$8
would be in
billion.
effect precluded.
And the court could...
Would that in fact preclude them?
In effect, the courts have...
Come on, yes or no?
Courts have said yes.
Okay, well, that wasn't so hard, was it, to just say yes?
That's-
okay, then that's what I disagree with, at least that's my other issue. That is, a government-to-government deal takes away my right to sue if I don't like what the government did. And those are offsetting, troubling concerns to me. I do think privacy is real, but I also think the principle of my being precluded by a deal that the government said, because, you know, when governments make deals, let's be clear, governments have a lot of interest at stake. We're told by the German government, for instance, and State Department argue this as well, that what's at stake here is not just this particular deal, but generally German-American relations. That if we were to allow something which the Germans feel violates the deal, and maybe does violate the deal, because I don't think you're not violating if people aren't bound by it, that could affect other things. So that's the point that I make. What's the justification for precluding the rights of people who didn't like the deal and were never part of it?
They were... If we had not done this legal piece in the way we did it, in the limited form which we did it, which the courts have accepted, we wouldn't have gotten $8 billion in time.
I understand that, and I'm glad you did.
It's a
but why
trade-off.
should that stop other people from also...
Because then the companies wouldn't have paid the $8 billion. If they had known they were going to pay $8 billion, they would still be subject to...
Well, their
Nobody in
lawyers...
his right mind would have done that. No
then
company
maybe their
in his
lawyers
right
should
mind
have told
would
them...
have done
Mr. Chairman?
No, I'm going to finish. Maybe their lawyers should have told them that there was a possibility that this wasn't going to be final. Mr. Kent.
I can answer you the question from a practical point of view. Just recently, we have reached an agreement, part of the agreement from the German government. They are giving right now to survivors $150 million. 50,000 survivors are going to get $3,000. I had meetings with Germans, ambassador, and people that came from Germany to our office, and they told me point blank, Mr. Kent, why should we make any agreements with the Jewish side for Holocaust survivors if we cannot depend on the word, on the agreement?
I'll give you the answer that I would give them. I'll call them up,
Yeah,
maybe
please.
I'll tell them. Here's the deal. Why should you make the deal? Because your country, not you personally, did the most vicious thing in the history of the world. And if I were you, I would lean over backwards to fix it. And I must tell you this. I will live up to this agreement. I'll urge other people to do. But I don't speak for every one of the victims. And I would tell you this. If you're going to tell me that you think this is the right thing to do, but because 100 people, 1,000 people disagree, and you're mad at them, you're going to deny the money that you think you ought to give to these other people, that's not nice. That's what I would tell them. Is there any further? Yes.
I told the German government, and the German Foundation was not signed for a few months because I said to the Germans, I will not sign as a Holocaust survivor an agreement unless we will get a full apology from your government. So the money, I agree with you, not the key issue for me.
No, I'm not saying that. I'm saying the issue is, I would say to them, you do the right thing because it's the right thing, and you hope you get the best, but you don't say, I'm only going to do the right thing if I then get immunity from every other possible victim. And you know what? I think that they probably are better in reality than they are in the negotiations. We all in a negotiation situation tend to be a little nastier than we might be in the reality. Sometimes we threaten to do things that we're not really going to do because, you know, we'll see what happens. Is there any further discussion that we have?
Mr. Chairman, I do think privacy is important, but if we were to limit this...
Well, let's not debate this among ourselves. The committee can do that. We don't need...
I just... 20 seconds.
Very quickly.
Okay. If we were to limit the bill to those policies where the company hadn't had any contact with the insured or the family for 20 years...
I said, but that's markup talk.
Okay. Sorry.
No, those are areas that look, the bill, and, you know, everybody should understand, this does not come before us as yes or no. This is a bill which is subject to amendment. There are two different sections. There are different countries. I am certainly convinced that further action is relevant, but we will have a lot of conversations with people. And any of the issues that anyone listening feels could be further adumbrated, please feel free to adumbrate. Yes, Ms. Koch, get you the last word.
I know it's risky to do this, but I would say that I would want to point out that there was matching done of these records against all of the archival research, so that we would be sure that we
Wasn't that, you said that already. Didn't somebody say that already?
I don't know.
I thought somebody did. All right, well, go ahead.
And that through that process, we were able to also in our Pomeroy for Us report get to these errorless claims so that that was dealt with. And I would also ask that I could put into the record...
No, you don't have to ask. Anybody who wants to put anything into the record could put it in. That's the, Ms. Kent, what is it?
I just like to say, many times I heard here reports about the 15 billion, 200 billion, and so on. And I like to say, Will Rogers said that there are three lies. There is a lie, there is a big lie, there is...
Okay, Ms. Kent, you already said that you thought there was no reality to the numbers. If this is repetition of things already said...
I'd like to add to it. I was for a few years with Mr. Zoblet on the commission. He never said to me,
That is a whole new subject that we're not going to get into now and start a whole new debate. Remember, you've all had a lot of time. Nobody was held to the 5 minutes. The hearing is adjourned.
Thank you.